If you care about the future of American institutions, you need to focus on what I'm about to lay out. Subscribe to this channel and turn on notifications right now, because what unfolded today inside a federal courtroom in Manhattan wasn't just another legal headline. It was a live-fire test of whether democracy can function when powerful people decide the rules no longer apply to them. Here's what we know. At approximately 11:47 a.m., in the middle of active federal court proceedings, 3 of the most expensive defense attorneys in the country stood up from the defense table, collected their files, and attempted to walk out while a federal judge was still speaking. Let that sink in. Licensed officers of the court, sworn to uphold the Constitution, tried to abandon their client and exit a federal courtroom because they disagreed with a ruling. What happened next is something that, according to court historians, has not occurred in a U.S. federal courthouse in more than 20 years. Let me walk you through the sequence, because the details here matter more than the headlines. The morning session began the way many do in complex white-collar cases. Prosecutors sought to introduce financial records. The defense objected. Routine procedural sparring. Nothing unusual, until you understand what happened 48 hours earlier. Due to what court officials are calling a clerical mistake, a sealed filing was briefly uploaded to PACER, the federal court's electronic records system. It was visible for just 17 minutes before being taken down. That was long enough. Legal researchers captured the document. According to multiple individuals who reviewed it, the filing contained newly obtained evidence, encrypted communications between Trump and his co-defendants during a period the defense had repeatedly described as a total communications blackout. The materials reportedly included wire transfers totaling $4.7 million, and what one source described as the most comprehensive paper trail ever assembled in a modern white-collar prosecution. This morning, Judge Patricia Caldwell ruled that all 847 pages would be admitted into evidence. That's when everything detonated. Lead attorney Robert Sterling rose from his seat. The court reporter, Maria Rodriguez, recorded every word. Sterling allegedly said, "Your Honor, this court has abandoned even the appearance of neutrality. We cannot participate in what has become a preordained spectacle." Co-counsel Jennifer Matthews followed, stating, "This is prosecutorial misconduct of the highest order, and we refuse to legitimize it by remaining." Then they turned toward the door. Now, understand this context. Judge Patricia Caldwell is a Reagan appointee. She has spent 31 years on the federal bench. Among defense lawyers, drawing her courtroom is widely considered good fortune. She is known for restraint, fairness, and near-legendary patience. And yet, as 3 attorneys attempted to walk out mid-trial, she looked up and said words that are now part of the official transcript. "Counsel, take one more step toward that exit, and I will hold you in criminal contempt and issue bench warrants for your immediate arrest." She then ordered U.S. Marshals to secure the room. Within seconds, 6 armed federal marshals positioned themselves at every door. The standoff lasted exactly 7 minutes and 23 seconds. If you're finding this breakdown useful, hit the like button now, because this story only gets more serious from here. Here's what Judge Caldwell revealed next, and why the defense reaction suddenly made sense. She disclosed that she had received a sealed ex parte submission from the Department of Justice earlier that morning. For anyone unfamiliar with federal procedure, ex parte filings, communications seen by only one side, are extraordinarily rare. Judges allow them almost exclusively for national security issues or witness safety. Judge Caldwell stated on the record that based on the contents of that submission, she was considering enhanced security measures and possible jury sequestration. Every experienced criminal defense attorney in America knew what that meant instantly. There is a cooperating witness. Someone close has flipped. Former federal prosecutor Andrew McCarthy said on Fox News hours later, "When defense lawyers hear about a sealed ex parte filing in a case like this, they know the walls are closing in. Someone on the inside is about to detonate a bomb." And suddenly the panic made sense. Let's connect the dots, because this is where the legal drama becomes something far bigger. Within 30 minutes of returning to their seats after the standoff, Sterling's team filed an emergency motion for a mistrial, citing judicial bias and prosecutorial misconduct. At the same time, they filed a motion to recuse Judge Caldwell, arguing that her threat of arrest showed personal hostility. Do you see the strategy? By creating chaos, they manufactured appeal issues. Legal analysts across the spectrum agree. This spectacle wasn't for the judge. It was for an audience far beyond that courtroom. And here's why that matters. Multiple sources say Fox News had camera crews staged outside the courthouse nearly 45 minutes before the walkout attempt. Conservative commentators began tweeting about judicial overreach before news of the incident had even broken. How did they know? Subscribe now if you want to follow where this trail leads, because the implications are staggering. According to DOJ sources, the sealed submission relates to testimony scheduled for next Tuesday from an individual identified only as Witness 14. This witness allegedly has first-hand knowledge of the financial transactions at the core of the government's case and has been in protective custody since October. That level of protection is typically reserved for cases involving organized crime or national security threats. The defense meltdown occurred exactly 96 hours before this testimony is set to begin. Coincidence? The timing answers that question for you. Speculation is rampant about who Witness 14 might be. The leading theory points to someone deep inside Trump's financial operation, a CFO, controller, or senior financial officer with direct access to internal records. If this witness testifies as prosecutors expect, the damage could be devastating. After order was restored, Judge Caldwell delivered a statement that sent shockwaves through the legal community. She said she was considering appointing shadow counsel to protect the defendant's Sixth Amendment rights. Shadow counsel are court-appointed backup attorneys, seated at the defense table, ready to take over instantly if current counsel attempts withdrawal. It's the legal equivalent of understudies, except the stakes are freedom, precedent, and institutional legitimacy. The financial consequences are already surfacing. Sterling's firm has billed more than $12 million in fees, according to public filings. Late Friday night, Bloomberg reported the firm entered emergency discussions with its malpractice insurance carrier, which is reportedly concerned about liability exposure if today's events lead to a mistrial or successful appeal. Industry insiders say partners could face personal financial risk. That helps explain why senior leadership was reportedly seen entering the firm's Manhattan offices late Friday night for an emergency crisis meeting. Hit like if you understand why this goes far beyond one defendant. Because here's the bigger picture. If attorneys can walk out of court whenever rulings don't go their way, the judicial system collapses. Judge Caldwell made that clear when she stated, "This court will not permit counsel to manipulate proceedings through calculated disruption." She's right. Once that door opens, every defendant facing conviction could attempt the same stunt. History backs her up. In 1978, mob attorney Frank Regano attempted a similar maneuver and faced disbarment threats. In 1992, during the BCCI scandal, defense lawyers were forced to continue under contempt warnings. In 2009, Bernie Madoff's initial legal team tried to withdraw mid-case and were compelled to stay. All three defendants were convicted. All three legal teams paid a professional price. The political response was immediate. Within minutes, Trump posted on Truth Social, accusing the judge of election interference. The post reached millions within an hour. Senators weighed in. Tom Cotton cried "Banana Republic." Elizabeth Warren countered that no one, not even lawyers, is above the law. Even Alan Dershowitz said on Newsmax, "Walking out on a federal judge is indefensible. When Alan Dershowitz won't defend you, something has gone very wrong." Here's a detail now circulating among court insiders. A defense paralegal claims Sterling received a text at 11:42 a.m. 5 minutes before the walkout. 2 words, "abort mission." The message allegedly came from a senior political strategist advising on optics. If accurate, this transforms today's chaos from legal misjudgment into deliberate political theater. Judge Caldwell seems to suspect the same. In a written order issued later that evening, she warned that coordinated theatrics with outside parties would be met with sanctions, contempt, financial penalties, and potential bar referrals. A federal judge is now on record suggesting courtroom drama was politically orchestrated. Security has since been elevated. Additional screening, increased law enforcement presence, federal agents placed on standby. This is not normal. International reaction has been swift. European legal analysts expressed disbelief. British and French media described the incident as unprecedented. Russian state outlets predictably framed it as proof of American institutional weakness. And here's the final twist. Sources say Trump's inner circle is now discussing replacing the entire legal team, possibly with even more aggressive attorneys. If so, Judge Caldwell faces an impossible dilemma: allow withdrawal and delay the trial, or force unwilling counsel to continue and invite appeals. One former Supreme Court clerk called it brilliantly cynical. The prosecution, meanwhile, is reportedly considering an extreme move, seeking bail revocation based on courtroom disruption. Unlikely to succeed, but powerful in shaping perception. The jury is watching, and jurors notice everything. Monday morning, Judge Caldwell will rule on the mistrial and recusal motions. If there's another disruption, arrests are on the table. What we witnessed today wasn't just legal maneuvering, it was an attempt to turn a courtroom into a campaign stage. The question now is whether the system holds. Subscribe, turn on notifications, because when witness 14 takes the stand, when the judge rules, and when the truth behind that abort mission text emerges, you'll want to see it in real time. This isn't just about one defendant. It's about whether the rule of law still functions when tested by power. I'll see you Monday.